Yes, well. Thank you so much, ladies and gentlemen. Yes, Council Eddie, may I know if you can get me well? Council Eddie Nangulu? Yes, Council Eddie, may I know? Yes. Let me fast read.
Yes, Adam, we are good to go.
Yes, may I know if you can hear me well?
Yes, Adam, you're very clear. I can hear you, my brother.
Okay, thank you so much. So, ladies and gentlemen, thank you so much for coming in this very big number. I would like you to permit me and hand you to our interim secretary and our representative of the Council in the Eastern, Council Eddie Nangru. Council Eddie Nangru, please take over and we begin our space.
Wow. Good evening. Adam, I hope I'm clear enough for members to hear.
Very much.
Yes. When you hear any lapses, please let me know. I am connecting from the slopes of Mount Elgon. If there are any network fluctuations, I can easily move to the higher altitude to be heard audibly. Good evening, everybody. In your different capacities, I want to welcome you to this space organized by the ULS. It's us hosting this space here, mostly because what is being discussed is central to our hearts, central to our existence, central to our establishment. I see a number of familiar faces. I saw the CEO. She was on earlier. I think she must have skipped off. Robert, a loyal stalwart of the Radical Nuba. I see Opit, another loyal stalwart. Council Enen, you say things plainly. You say things clearly. You don't mince your words. Really radical. Raymond, Bruce, and every other person who is joining us this evening. I want to welcome you for this space. This is, I think, our third or fourth space. I can't be sure, but it is one of the many spaces we have been organizing to engage the membership, sensitize them, but also account to the members based upon the mandate that they bestowed. I see Council Jude online. I see also our president and many other members whom I can't go on to call out. I want to thank you for giving your time this evening to follow the developments in the Radical Nuba and to hear from us what we are designing, what we are planning for the membership. Today's X-Space is organized under the theme Setting the Record Straight, understanding the role of the Radical Nuba in the current judiciary impasse. Let me just repeat it. Setting the record straight, understanding the role of the Radical Nuba in the current judiciary impasse. Jude, please find an area where you have the most stable network. I need you to be near to be able to also make a contribution on what we're going to be discussing. Our keynote speaker this evening is our Vice President, the most perpendicular, Mr. Asemwe Anthony. He'll be joining us on this call shortly. He has had a long week, really, even if it is just halfway down the road. He has been commanding the troops and rallying us to achieve what we set out under the Radical Nuba. We shall have on call our president. I see him is online already. He's fired up. He's ready to set us ablaze. That is just how I can simply put it. Set ablaze our spirits and our souls in this radical journey. So I would thank you and welcome you once again. Now, in today's discussion, and largely what we're going to be centering on, there has been a lot of misrepresentation. Mr. Simo, I see you've joined. You're most welcome on call. We're happy to have you. There's been so much misrepresentation, mostly by those that are envious or are offended by the achievements of the Radical Nuba. Many of them have never recovered from the previous electoral loss, and they have set a number of traps in our path, hoping that the Radical Nuba would fall, having failed to achieve. Can you still hear me, Adam? Adam?
Yes, Council Ed, you are very loud.
Okay, please, thank you. Sorry, I had a network disconnection or disruption. I was saying that there's been a lot of representation. Having failed to see the Radical Nuba fall in their traps, they have now begun a propaganda agenda, misrepresenting, misleading, misguiding, misstating facts. A number of facts are that the Radical Nuba has designed this current state we're in. Radical Nuba is encouraging the current status quo. Radical Nuba has driven us into this rut here, and they are unable to get us out of it. They talk about the appeals with so much misinformation. They talk about our vision 2060 with a lot of ignorance. And for the unsuspecting public, many believe that what they are saying could be true. And because of that, it is important that we come out this evening to set straight the record. We have on call Counsel Jude. He has been our lead counsel on all our court matters. Today he was trying to put out fires that were misrepresenting that after some time our appeals shall be rendered moot and the journey that we are trying to pursue would be of no legal effect. It is important that he would be on this call. Robert too has been running around to our court processes. So it's going to be an exciting evening. It's going to be informative and really it's going to give us direction, mostly because tomorrow, Thursday, is the day we had been given for hearing, the 10th of July. Our call had been, we must be on the tarmac tomorrow. We must demand for our rights. We must demand for the president's right to have his case heard. Earlier this week here, you came across the letter by the DCJ. The DCJ issued a response to the Vice President's request that our matters should be returned on the causes and we must be heard. This response had been issued in response as well to a letter by the Registrar of the Court of Appeal, who had informed us that instead of coming up for hearing, we were not going to have our cases heard, and we were going to appear before the Registrar's Court for conferencing of the matter. Of course, we didn't agree with this position, largely because, and we kept insisting that conferencing isn't a prerequisite or isn't mandatory before you can have an appeal take off. And we made our reasons known, placed them on paper, and sent them to the DCJ. Now, the DCJ's letter has run around. Each of us has largely read that letter there. What for me was most shocking, and what should shock everybody, is the DCJ's categorical position in calling persons who are seeking justice lobbyists, categorically and unequivocally stating that he will not relent as long as he has breath in his system. Of course, it came as a shock to everybody. It came as a setback, mostly to any persons that are eager and concerned about the rule of law, good governance, and justice. Of course, a number of shocking factors are that there are appeals in the court system that have lasted for 20 years, and he asked us, or not even us per se, he said that he would not schedule our matters until they have disposed of whatever has been existing for the past 10 years. This was a massive setback. It did indicate that he was oblivious to the importance of the matters. He's adopting a mechanism of scheduling that one is unjust, is unfair, improper to even apply in a system such as, or in the current circumstances. But he said, of course, that he would not relent and he would maintain his stance regardless. Now, this morning, a number of persons aggrieved by that position there came out to make their voices heard. Of course, the VP will narrate to us. The VP was the first to issue a notice, of course, thanking him for giving us audience and seeking audience again to discuss the matters further. That meeting happened today, and I will let the VP discuss the detail of that meeting and what compromises or what situation was arrived at for the benefit of the Radical New Band, the membership. I want to go into some of the letters that came out today. This was after the VP's letter had been received by the DCJ. The first one that we learned of was one issued by Counsel Musinguzi Arnold Mugisha. It was all over our social media platforms, but I will just run through the key points just to enable you to understand where the VP is coming from on his insistence in his keynote. The letter is addressed to the DCJ. The reference is ULS appeals coming up on Thursday, the 10th of July, 2025 at 9 a.m. Musinguzi has this introduction. I am a proud member of the ULS practicing within the fraternity of the Mbarara Bar. I have diligently read your letter of 7th of July, 2025, Samba in brackets, addressed to the ULS Vice President and copied to all members of the ULS trying to understand the issue between judiciary and the ULS. I regret to say that I have failed to understand the issue. Apart from your seemingly obvious dislike of the Radical New Bar, where the ULS Vice President belongs, and the values of transparency and accountability for which it unapologetically stands. As far as I understand, ULS is concerned with the official reason why the registrar attempted to remove its appeals from the cause list. In her own words, she says through letters dated 30th of June and 3rd of July of this year, that the appeals had been erroneously cause-listed because the parties had not completed conferencing. However, in your own letter, you contradict the land registrar by saying that she was acting under your directive, which based on a policy for which you are ready to die. That is, only appeals that were filed 10 years and above should be on the cause list, with the exception of election petitions. With great respect, there are two problems with that hardline policy. One, failure to notice that the ULS appeals arise from statutory election petitions as well. All elective officers of the ULS are a creature of either the Constitution or a statute. By the way, there are many statutes that require ULS representatives, and the beneficiaries of those statutes, including the Judicial Service Act, cannot wait for 10 years for the judiciary to resolve ULS election petitions. Therefore, your policy amounts to injudiciously suspending the Constitution and many statutes of which you are perhaps not aware when you wrote your letter. 2, selectively applying your reason to ULS appeals only. I've looked at the cause list of the ongoing civil appeal sessions, and there is no case that was filed 10 years ago or above. I wonder why you didn't remove all those cases, but you removed the ULS appeals. This is a clear violation of Article 21 of the Constitution on the equal administration of justice. Of course, you remember that the DCJ was about Article 21 as its basis for striking out our peers. In conclusion, I invite you to drop hatred of the radical new bar, for it's here to stay. Our program is called RNB Vision 2060, and within it are many beautiful things for the benefit of judiciary, the legal profession, the government, and the entire public, including how to win the war on case backlog, but smartly and scientifically, reforming cause listing procedures in all courts of Uganda. You'll be surprised that many of the cases of 10 years ago and above have no active litigants interested in them. So organize for them a special weeding out session instead of using them to block the pipeline for cases which are relevant now for Uganda's democracy. I look forward to traveling to Kampala on Thursday to attend the ULS appeals hearing and to meet you to see how to align your office plan with the Radical Nuba program, RNB Vision 2060. Signed, Advocate Musinguzi Arnold Mugisha. That was the first letter that we saw. We saw in the morning while we were still discussing what would be the possible way forward. Then while we were still contemplating, trying to appreciate Arnold's letter, then our own stalwart, Enen Ambrose, and then was among the first persons to come out to speak about the DCJ's letter when it was issued. That was the first space that we held, just to break down the ongoings, the circumstances, the consequences, the implications of that letter. So Enen put pen to paper. He went beyond beyond talking. In his letter, the reference is attendance at hearing of ULS appeals at the Court of Appeal session on July 10th, 2025, and demand for action on alleged judicial impunity. I write to you a copy of your letter as a member of the Uganda Society and the ULS Judiciary Affairs Committee. Having received a copy of your letter responding to the ULS Vice President regarding ULS appeals, which was circulated to all ULS members. As such, I have personal knowledge of its contents and the serious concerns raised therein. In your letter, you stated that there are many lobbyists in the corridors of the Court of Appeal. This must end immediately. As long as I have breath to head the Court of Appeal, I cannot be part of the broken system of cause listing. I was appalled by your insinuations of corruption within the Court of Appeal, which, if true, strike at the core of judicial integrity and public confidence in our justice system. As a member of the ULS Judiciary Affairs Committee, I am compelled to address these grave allegations instead of retaliating against the ULS Radical New Bar and its president, Isaac Simakali Chimaze. I respectfully call upon you to submit all relevant evidence of misconduct or corruption within the Court of Appeal to appropriate authorities, including the ULS Judiciary Affairs Committee. This will enable us to initiate thorough investigations to ensure accountability and safeguard the judiciary's independence. The legal fraternity and the public deserve clarity and coherent decisive action on the matters raised. As long as I have breath in me, I will attend the Court of Appeal session on July 10th, 2025, to observe your Lordship's fidelity to the rule of law, even especially when the Radical New Bar is the appellant. On this, I am not willing to relent. Carefully worded, interesting phraseology, powerful response, radical, all through and through. Council Ambrose Enen. I see we have been joined by the Treasurer. You're most welcome, Treasurer. We're just trying to give a background to why the VP is on call today to set the record straight. Now, all these letters here, of course, have been circulating. It's important that the record on what exactly prevails is made straight. For me, this one is the most important because it was designed by the Eastern Bar. It is much longer than all the rest. I hesitate to read the whole of it. But yesterday evening, 90 plus members of the ULS Eastern Bar, of course, we are disturbed by the DCJ's letter, and they put pen to paper. I'm hoping we have seen the Eastern Bar's response, but I can just run you through the key highlights. The reference is the ULS Eastern Bar response to your communique withdrawing ULS appeals from the Court of Appeal cause list. We, the undersigned members of the ULS Eastern Bar, do acknowledge receipt of your communique reference number that copied to all members of the ULS Society, and would like to respond as hereunder. We have carefully scrutinized your aforesaid communique in trying to understand the circumstances that inform the decision to cause the withdrawal of the ULS appeals from the cause list. We are deeply concerned that appeals are lasting for as long as 20 years in the court system. We pointed out this critical form of injustice to your predecessor, the now retired Honorable Mr. Justice Richard Butera, who promised reform. The systemic delay at the Court of Appeal was a prevalent concern during the recent Eastern Bar prisons engagements. That said, the ULS appeals aren't just everyday ordinary appeals. The said appeals raise fundamental questions, fundamental constitutional and public interest issues that require urgent attention. The first appeal is number 99 of this year. It is ULS versus Fiona Wall. We did explain that this appeal bears on the constitutional obligation of the ULS to nominate members to represent it at the 7th Judicial Service Commission. The fundamental relevancy of the JSC need not be stated. However, the said commission has to this day not been fully constituted on account of the fact that the ULS representatives have not yet been elected as ordered by the High Court in HCMC number 129 of 2023, Karali Stephen versus ULS. This must concern the judiciary because the current vacuum at the JSC undermines the constitutionality of any decisions taken by the JSC. Currently, the appointment of the principal judge, chief registrar, 2 deputy registrars, 3 registrars, 1 chief magistrate, and 1 magistrate, grade 1, is underway without the input and or consideration of the members of the bar, who in turn represent the voice of the public. Soon the same commission will sit to consider the appointment of the next chief justice of this country. Even if you would not want to understand, even if we would want to understand your backlog situation, the entire country is bound to bear the brunt of the unconstitutional processes underway at the Judicial Service Commission. This burden cannot be borne for the next 10 years while the backlog is being cleared. The next appeal is number 61 of 2025, ULS versus Brian Kirima. This appeal is intended to restore the mandate of the members to requisition for a general meeting to attend extraordinary business, which often concerns mitigating threats to the judiciary and the administration of justice. The trial court on the 5th day of February 2024, this was Justice Sekana, injuncted the ULS from convening any extraordinary general meeting, even when circumstances warrant. Asking the members to continue in this predicament for 10 years is not only embarrassing but unjust and unfair. Now, as we go on, of course, Jude, our lead counsel, shall speak more to these pending appeals. The next appeal is civil appeal number 98 of 2025, Eddie ULS and Eddie Nangolo versus Mugisha Hashim and 2 others. This one is crucial to the internal governance and democratic integrity of the ULS. It is critical in addressing the role of the General Assembly in determining elected representatives and the right to suspend, remove, or maintain any such reps. There are many elective offices within the ULS, which are a creature of either the Constitution or numerous statutes. On 14th of February 2025, the trial court made declarations that make it impracticable to convene the General Assembly by order of council, which is the sine qua non for conducting elections of council members and the ULS reps to various bodies, thereby suspending all elections. This appeal greatly impacts the administration, auditing, and the sending of elected society reps to the constitutional and statutory bodies in this country here. Deferring the same for 10 years impliedly maintains the current leadership impasse and embarrassingly freezes both the council and the General Assembly. The final and the most important appeal is the one for the president, civil appeal number 102 of 2025, Isaac Semakade versus Mugisha Hashim. This is important because it's the most glaring of all the appeals. Deferring it for 10 years condemns the president to exile for the length of that period. The impact on the society and its membership is evident, especially since the president cannot effectively represent members of the bar at key bodies requiring personal representation like the Law Council and many others. Our conclusion was, in light of the foregoing, we urge your lordship to kindly relent in the interest of justice and reconsider your directive, given that the ULS appeals on the cause list arise from time-sensitive election disputes, and therefore prompt resolution is essential for maintaining constitutional harmony in this nation. With great respect, this clarification may not have previously been brought to your attention. We're optimistic that you now see why ULS matters should be heard on the 10th of July 2025. We shall appear in court on that date for hearing. This is signed by the 90 plus members hailing from the Eastern Bar to stress the importance and to also insist that the court should not take these matters here for granted. Now, I have run through those letters there. Those were letters that were written locally, but on many other platforms. I see Mr. Garu has joined us. Mr. Garu, you're most welcome. I hope you're well. We were running through the different letters that have been running around. You missed to hear the remarks by Mr. Enen. Mr. Enen made an interesting comment, which if you'd let me, I would. Mr. Enen said, as long as I have breath in me, I will attend the Court of Appeals session on 10th of July. Tomorrow, that is tomorrow, to observe his lordship's fidelity. And then he says, on this, I'm not willing to relent. A number of others, including the one from the Eastern Bar, I'm sure you did it earlier, which I was just been going through earlier. Each of these letters here just urging the DCJ to kindly relent in the interest of justice, stressing the importance of the ULS matters and why they should be given special attention at the earliest. That is tomorrow. Now the final letter is coming from yes. It is a 3-page document. I'm sure you have read it. Please bear with me. I wanted to give appropriate background so that each of us appreciates the ongoing legal debate on whether we should be heard tomorrow and how do we approach the situation. The letter of ELS is dated today, Tanzania, Arusha. Statement by the East Africa Law Society on the unlawful decoys listing of the Uganda Law Society appeals. The letter is introduced as follows. The ELS, the umbrella regional bar association of the East African region, uniting over 45,000 legal professionals across the East African community, has learned with dismay of the unlawful decoys listing of critical ULS appeals by the Ugandan judiciary. This deliberate act undermines the ULS constitutional mandate, violates Uganda's international and regional obligations, and threatens judicial independence, imperiling the rule of law and democratic governance. ELS demands the immediate restoration of these appeals, strict compliance with judicial processes, and accountability for this egregious interference with the legal profession. On the 3rd of July 2025, the Court of Appeal Registrar, Her Worship Rukundo Allen Owembabazi, issued a letter removing 4 pivotal ULS appeals: Civil Appeal number 61, 98, 99, 102 of this year, all of this year, from the cause list scheduled for 10th July 2025 at 9 a.m., citing erroneous cause listing. In a letter dated 4th of July 2025, ULS Vice President Asingwe condemned this action as a procedurally flawed and legally indefensible, accusing the registrar of bias and manipulation of the court. This decoys listing violates Rule 20 of the Judiciary Court of Appeal rules, which vests cause listing with judicial authority, prohibiting unilateral registry revision. The registrar's directive to redirect these matters to conferencing lacks legal foundation, as affirmed in Security Group Limited versus Maristops Uganda, Civil Appeal number 1562/2013, which holds that conferencing is not mandatory for appeals. The decoys listed appeals are integral to ULS's constitutional mandate under Article 1462 and C of the Constitution on nomination of reps to the 7th JSC and its statutory duties under Section 15 and 16 of the ULS Act on convening general meetings. They address critical issues, the obstruction of court-mandated JSC elections as ordered by the High Court on 2nd of February 2024 in Parali Stephen versus ULS, the frustration of member requisition and counsel under general meetings, alleged judicial harassment of the ULS president, and the deepening rift in the bar-bench relations. By paralyzing the ULS operations, this action erodes public trust in the judiciary and jeopardizes a crisis of constitutional governance. The decoys listing also constitutes a systemic violation of Uganda's domestic and international commitments, including International Covenant on Civil and Political Rights, the African Charter on Human and People's Rights, the Protocol to the African Charter on the Establishment of an African Court on Human and People's Rights, the UN Basic Principles on the Role of Lawyers, then the East African Community Treaty of 1999. By tolerating this procedure sabotage, the judiciary of Uganda breaches these binding norms, fostering perceptions of bias and administrative overreach to undermine its legitimacy. To preserve judicial independence and allow ULS effectively deliver its mandate, we unequivocally support ULS's call for members to assemble peacefully at the Court of Appeal. Let me just repeat this part here. To preserve judicial independence and allow ULS effectively deliver its mandate, we unequivocally support ULS's call for members to assemble peacefully at the Court of Appeal on 10th July 2025 at 9 a.m. to demand the hearing of these appeals. This gathering is a lawful defense of constitutionalism, judicial accountability, and the legal profession's integrity. We demand the following. 1. The immediate restoration of the appeals. Reinstate Civil Appeals number 61, 98, 99, and 102 of 2025 to the Court of Appeal cause list for 10th July 2025 at 9 a.m. Number 2. Adherence to judicial rules. Enforce Rule 20 of the Judiciary Court of Appeal rules prohibiting unauthorized registry interference. Number 3. Independent investigations should be launched into launch a transparent inquiry into the registrar's actions with disciplinary or legal consequences for procedural violations. Number 4, protection of ULS's mandate, safeguard ULS's constitutional role in the GSC nominations and statutory governance duties from further obstruction. Bar bench dialogue, convene an urgent discussion between the judiciary and the ULS by 31st of July 2025 to restore trust and strengthen judicial independence. The last paragraph is the failure to comply will compel ELS to pursue regional and international remedies, including petitions to the ESCJ and mobilization of strategic litigation. ELS reminds the judiciary of Uganda that its authority derives from fidelity to the rule of law, not from administrative caprice. A judiciary that obstructs justice undermines its own legitimacy and imperils the republic. ELS stands resolute in defending ULS and the principle of justice, accountability, and democracy across the East African community. The restoration of the ULS mandate is our collective imperative. This is signed by Ramadan Abubakar, the President of East African Society, July 9th, 2025. Comrades, I have run through most of the key important documents for us to best appreciate in this discussion here. Our keynote speaker is not online. Adam, as Adam, please help me trace for the VP getting back online. I see Council Mochibi has joined us. Council Mochibi, you're most welcome to the space. We have just run through the volumes of letters and the demands by members to have our matters heard tomorrow. Adam, VP is not online. Please help me trace him. In the meantime, I'm going to invite Council Jude Yamukama. He's our lead counsel in these matters here. Jude, as I said earlier, you are putting out fires on the Court of Appeal platform. Members have been misrepresenting about these appeals. There has been a lot of debate about why don't we withdraw? Why haven't we gone for the elections? What is the hold-up? What is the insistence? As counsel on these matters here, there are members that eagerly want to know. I've run through briefly what these appeals are about and what may be, why they are dear to us and why we are pushing for them to be heard. But we could hear your voice briefly as we get our keynote speaker on. Share your thoughts, please, Jude. The floor is yours.
Thank you, Eddie, and good evening, members. This is indeed a challenging time for us as Uganda Law Society. Some effort has been made to go through the appeals that we have in the Court of Appeal, but maybe to clarify a few points. First of all, the appeals which originate from the judgments of the High Court that were made firstly on the 14th of February of this year, and then one appeal that originates from a ruling that was made by the High Court last year in February. So we have there are four appeals that live appeals in the Court of Appeal. Those four appeals, if I can just quickly go through them. This year in February, on the 14th of Feb, the High Court delivered 3 rulings. The first ruling was in the matter of Hashim Mugisha versus Uganda Law Society and Eddie Nangulu. The High Court made a number of declarations and orders. First of all, holding that the majority of council members didn't have power to suspend a member of council who had tried to carry out a coup by dismissing the president and the vice president. The court ruled that majority of council members could not suspend that member. And the court also made orders touching questions to do with how the elected council of Uganda Law Society is supposed to operate. And the court basically indicates that all the members of council must participate in decision making. That is a bit problematic because by law, even the Interpretation Act permits quorum requirements. The court also pointed out made a number of other findings, which more or less make it impossible for the governance of Uganda Law Society to operate normally. One of the big questions remains: if a member of council, if an elected member of the Council of Uganda Law Society misbehaves and attempts to carry out a coup, are the majority of council members powerless until an extraordinary general meeting? We are of the view that the court got the answer to that question wrong, because the court is basically indicating that other members of council are powerless. There's nothing they can do about it. And we respectfully do not agree with that. The second ruling that the court delivered on the 14th of February this year concerning the parties were Fiona Wall versus Uganda Law Society and Moses Mwase. Mr. Moses Mwase is the chairperson of the Elections Committee of Uganda Law Society. Essentially, the orders made were that our member, Fiona Wall, who is also a former president, should be treated as a lawfully nominated candidate to contest to represent Uganda Law Society to the Judicial Service Commission. This member, according to the judgment of the Elections Committee, did not have 15 years standing as an advocate to be eligible to contest. 15 years is the legal requirement under Article 146 of the Constitution. Article 146 of the Constitution requires that to be a member of Judicial Service Commission representing Uganda Law Society, you must be an advocate of at least 15 years standing. And the Elections Committee took the view that intending candidate Fiona Wall didn't have the 15 years because she was enrolled as an advocate on the 16th of June 2010. That means that she attended the 15 years standing as an advocate on the 16th of June, just last month. But the nominations were last year in November. Is it November or October? If I recall very well. And therefore, the decision of the High Court, which ordered that the candidate should be considered to be duly nominated, was quite troubling because, as far as the Elections Committee is concerned, the High Court was forcing them to violate a provision of the Ugandan Constitution. And therefore, those two matters were appealed. The third matter is Brian Chirima versus Uganda Law Society. That matter was filed in February last year. That was before the current even leadership of Uganda Law Society. And essentially, the High Court issued an order of a temporary injunction prohibiting members of Uganda Law Society from petitioning to convene extraordinary general meetings. Now, the power to convene extraordinary general meetings is created by the Uganda Law Society Act. Any member of Uganda Law Society is entitled to petition for conduct of an extraordinary general meeting with the support of 15 members, 15. There is a lot of debate about that clause, but it is the law. And if we are Uganda Law Society, we have to respect the law. Right now, the membership of Uganda Law Society is over 5,000, and therefore, it is fair and legitimate to be concerned that 15 members who don't even constitute 1% of membership can cause the whole Uganda Law Society to convene an extraordinary general meeting. There is legitimate concern about that. But now the problem we have is that the High Court issued an order basically prohibiting Uganda Law Society from organizing members based on petitions by members for meetings. That was a direct violation of the Uganda Law Society Act. The High Court makes an order that violates the statute. That is a grave problem. And we realized it was necessary for that order to be appealed so that at least the record is set straight and the provisions of the statute are respected. Any members or leadership that may not be happy with that provision, the solution to that provision lies in amendment of the law, but not in seeking an order of the High Court to stop operation of a provision of the law. That is quite problematic. So that is the third appeal that is pending in the Court of Appeal. The fourth appeal concerns our president. The High Court on the 14th of February convicted and sentenced him in absentia and without a hearing on a contempt finding and sentenced him to 2 years imprisonment. He filed an appeal against that decision. So those are the 4 appeals that are pending in the Court of Appeal. And ever since the appeals were filed, we knew they were very urgent. And we always believed that these appeals would definitely be given priority by the Court of Appeal because it was obvious appeals are urgent. First of all, the inability of Uganda Law Society to conduct elections for our representative to the Judicial Service Commission means that the Judicial Service Commission is operating without quorum as per the Constitution. The Constitution requires the Judicial Service Commission to be fully composed. When it comes to quorum for meetings, that's different, but it should be fully composed. And there indeed is even a decision of the Constitutional Court concerning proper constitution of a constitutional body. So we therefore continue to believe that these matters are urgent and members need closure. We strongly believe that the decisions of the High Court were made in error, and we would like the Court of Appeal to give them a second look. We are not saying that we shall succeed at the Court of Appeal. All that we are asking for is to be heard, and then the Court of Appeal will make its decision one way or the other. And then we shall look at the decision and determine whether it requires to be appealed to the Supreme Court or whether we need to comply with it and let it go. So that is the nature of the appeals. These appeals, therefore, touch the normal functioning of Uganda Law Society and the ability of Law Society to elect its representatives to the Judicial Service Commission. And then, of course, most importantly and fundamentally, one appeal also touches the question of the personal liberty of the President of Uganda Law Society. We question whether it is proper that an individual can be sentenced for contempt without being heard. The procedure for even contempt proceedings was the Supreme Court gave guidance in the matter of Ivan Sebaduka, and that guidance was not followed at all. So there are several serious questions that need to be answered to be sure that we get propriety in the manner in which contempt matters are handled, and therefore these matters remain unresolved. We have attempted, and again, the members need to know this. We have attempted to go through to mediate these matters, not once, not twice. We have tried to reach out. The Uganda Law Society Council has tried to reach out across the aisle to the other side, to the respondents, to see if we could talk and resolve these matters amicably as members of one family, the Uganda Law Society. Those mediations have not been successful, and therefore it only became imperative that the court should hear us and then decide the matters one way or the other. And that's where we are. So what transpired was that in the month of June, we were happy when the court wrote to us asking us to file our arguments. We were given a very short time of 2 working days. We protested and requested for more time. Then eventually we filed our arguments. The respondents did not reply, although I think one of the respondents has replied today. We had this belief that all was on course and we were looking forward to being heard. by a panel of 3 justices of the Court of Appeal. And then last week, we were shocked to receive a communication, instead telling us to go to report for conferencing before the registrar, instead of a panel of the 3 justices of appeal, as per the cause list that we had obtained from the registry of the court. And therefore, a lot has gone on. I don't have to repeat it. We've tried to reason with the court to try to make sure we are heard. It's a difficult situation. We will continue to request to be heard, because surely the right to be heard is sacrosanct. And these are urgent matters that touch the normal functioning of the legal profession in this country. I thank you very much.
Good.
Yes, Eddie.
Yes. Jude, thank you. Let me just a follow-up question, my brother. You speak of the JSC as an important issue for the ULS. And the clog in that journey is Fiona Wall. Fiona Wall has now obtained the required 15 years. We are still litigating with her. Is that a worthwhile journey? Members are asking for us to maintain.
I think that is a very fair question. The question of how we approach the Fiona Wall situation. There are 2 ways around it. We have to remember that nominations for candidates were carried out last year in November. So question 1, if we do fresh nominations, definitely Fiona Wall is eligible to participate if we do fresh nominations. But the High Court judgment gave an order that Fiona Wall should be added to the list of nominated candidates. So if we went for fresh nominations and she declined to participate and we closed the nominations without her, won't we be in contempt of the High Court decision? That is one area. The second one regards whether we should simply go ahead with the conduct, or whether the elections committee should simply go ahead with the nominations as order, maintain the nominations and disregard their concerns about Article 146 of the Constitution. The elections committee has been uncomfortable with that, because Uganda Law Society, we have to be role models in respecting the rule of law and observing the Constitution. If we start violating the Constitution because there is a court order that is forcing us to violate the Constitution, it can be problematic. But if it is an order that is final and maybe has undergone review in the appellate courts and has been upheld, we would rest our case and say, fine, this is what it is. But obviously, this is a matter where we can continue to think about it. And I'm also encouraging the elections committee. And it's important for members to know that the elections committee of Uganda Law Society is an independent organ of the Uganda Law Society. It is not controlled by council. It was appointed, in fact, by the previous council, and it is governed by a statutory instrument, the Uganda Law Society election regulations. It will take its decision on how to go about this matter. But we all have a strong view that maybe we can find a middle way out of this. But those are the primary concerns on how to go about it. Those are the primary concerns. But yes, there could be a middle way. There could be a way to resolve it, because certainly it is important for the society if we are able to hold this election for our representatives as soon as possible. And we must continue to explore the alternatives to close this litigation, either by a decision of the Court of Appeal or by us finding another way. For us as the council, my instructions have been to continue to explore all the possibilities. We are happy to talk and try to find a solution, because it's really a big deal that we try to get this out of the way.
Okay, thank you so much, Jude. From the letters I was reading earlier, members have been disturbed by the DCJ's stance. As long as I have breath, I will not relent. But we intend to be on the tarmac tomorrow as lead counsel in this matter here.
Maybe to say something more about the letter by the Deputy Chief Justice. First of all, when we picked that letter, myself and the CEO Uganda Law Society and one of my colleagues in the law firm, we had what I can say was a very cordial discussion with the Deputy Chief Justice, and we explained it ourselves and why the matters of law society are urgent. The Deputy Chief Justice did not say that our matters can't be heard at all, so we should not read, I think, too much into the tone in that letter. Okay. We should understand that the Deputy Chief Justice did indicate to us, did indicate to me that he's amenable to our matters being heard. He appreciates that some of them have an element of urgency. He doesn't think all of them have urgency. I respect.
Yes, good.
But that's his position. That he does believe some of them have some urgency, but not all of them. He also believes that it should be possible for us to mediate these matters and try to close them off. So that's where we are, and it's important that therefore we put his letter in that context. It's the mood and our engagement with him was not as combative as the tone of his letter suggests.
Okay, thank you so much, Jude. One last, there have been misrepresentations, and that is where I even began from about these appeals, and we have September around the corner, and the Radical New Bar is supposed to renew its mandate then. Do you see us have these matters disposed of at the earliest, or how would you guide us in that regard?
I think I'm still very skeptical even on how we shall be able to conduct our annual general meeting this year in light of the High Court ruling, because it leaves us in a very, very difficult situation in how council takes decisions, if some members are in disagreement. Because if the judgment says, as it indeed says, that all council members must be in agreement, all it takes is for 2-3 council members to dissent from a decision and you have nothing to do. It's quite problematic. And therefore, I think it's still early days for us to navigate the legal landmines that lie ahead in our attempts to conduct an annual general meeting this year. What I can say is that regarding extraordinary general meetings, we may be having some positive developments. I don't want to preempt them, but their indication is that the matter of Brian Chirima may end much earlier in the coming days, because his lawyer didn't reach out to us but wrote to the court, indicating that they probably may not want to pursue the underlying matter in the High Court anymore. If they maintain that position and we get that matter out of the way, then maybe there could be windows to organize extraordinary general meetings and try to sort out ourselves in certain respects.
Okay, George. Thank you so much. So much hope there that you've given us. Thank you for leading the front and being our leaders in these cases here. Thank you for representing the ULS, the Radical New Bar. Thank you for being in those meetings there and holding forth for us. We are indeed grateful. I want to invite our keynote speaker, Mr. Asimwe Anthony, our Vice President. Mr. Asimwe, you have been all over the place and promoting our agenda. We are indeed humbled. Sometimes I wonder whether do you still have a practice? I wonder, have you sacrificed entirely to this cause here? We also are aware that you lost a grandmother just the other week, and we sympathize with you, with the family, and for you to be at the front line still, even at the funeral, you were available on call, you were guiding the response to the DCJ's what Jude is calling a combative letter. Was delivered while you were away, and as soon as you returned, you were before him advocating for the 10th of July. Over the week, there have been a number of misrepresentations, and it is key that we set the record straight and what our role is in this current situation. So allow me hand the mic to you to address us on these key issues. What happens tomorrow? Are we on the tarmac? Are we robbed? Are we in R&B? And how do we rally forth as a Radical New Bar? The floor is yours.
All right. Thank you, our most perpendicular Interim Secretary, Mr. Eddie Nangulu. Please confirm that you can hear me if I proceed.
Yes, I can.
All right. Thank you. Fellow council members on call, members of the bar online, ladies and gentlemen, a good evening to you all. Let me take this opportunity to appreciate all of you, those who are online, every member who has put in effort to support the cause of the Radical New Bar mandate, and more especially each and every one of you who has supported us through this very complicated, stressing, and emotionally draining journey so far. Most of you might not have an idea what myself and the council members have to go through on a daily basis, every minute of every hour of the day, of the week, trying to execute this mandate, the Radical New Bar mandate, against the efforts of the detractors who are, motivated one or another to frustrate the progress of the bar. I also do appreciate the members who have come out. At the beginning, you had Mr. Nangul read out the various, individual communications and letters from individual members who have decided not to sit back. And this is what has always been our call, that this is not Asimwe's fight, this is not Semakade's fight, this is not Nangulu's fight. It's the fight for all of us, and every member of the bar, wherever they are, should be interested in what happens in protecting our space, in protecting the independence of the legal profession, because that's our business. We need to protect our space, and if you do not fight for your space, no one is going to do that for you. So I do appreciate the members who have come out in a special way. Our regional bar, the East Africa Law Society, we do not take this support for granted. It's not the first time the regional bar is coming out to offer support and solidarity. We've seen it before. From the time we had issues, the liberty of our president being curtailed, they did come out strongly. They did support, and we do appreciate the president and the council and the regional bar leaders for standing with us in times like this. And coming back to where we are, people have been asking questions of, how did we get here? And Eddie, you asked about. Your concern was there are so many people saying different things, and we need to set the record straight. And for me, the other question, the big question most of us need to ask ourselves is, who is actually the enemy to the bar? Who is this enemy? Because amidst everything we're doing, as the Radical New Bar, we've set out a clear journey, clear mandate, the Vision 2060, what we need to see, what we want to be done, how the bar should look like by 2060. Well, we need to have an independent judiciary, an independent legal profession, because we are all aimed at achieving one goal, ensuring that there's proper respect for rule of law, the access to justice, which is not really a personal thing. It's not an individual battle, but rather this is a fight, this is a doctrinal issue for the bigger cause. Now, like Eddie has stated, you've had the genesis, the background. Jude has also made effort to explain, where we are. And if you've heard properly and clearly, since we came into office as the bar, we have not sued anyone. We are crying foul about the cases in court, from the lower court, the appeals, cases against the president. The president has never filed any case against anyone. The Law Society has not sued anyone. Incidentally, and what is shocking, everyone who has sued the bar, any matter that has been filed against the bar, they've been able to get very quick results. And they confidently move around, like by the time of filing, they know the result. They know the outcome. They even brag about it. And these matters are actually settled in a record time. Unfortunately, when you look at our appeals where we're not satisfied with the outcomes, one of the very first concern we have in all the appeals is that we've never had a fair hearing in the lower court. I think most of you remember during a matter where our counsel, Jude Yamukama, and whom I would really want to thank in a special way for holding fort and being relentless, sacrificing his time. At some point, I even told colleagues that we were about to collapse the farm. But you remember an unfortunate event where Justice Sekana, told him, you can submit to in the corridors, I don't need your submission, simply because he was asking for time, or saying we need time to come and explain orally so that you understand the context. And you're being told that, no, I will not give you that time. Where is the fair hearing? Where is the justice for the bar? And shamelessly, this is a person who says, no, I don't have the time. With or without your submissions, I'll still deliver my ruling. And we stand and look on, and that is what we're happy with. And I get surprised when I see some members celebrating some of these events. From the position where I stand and where the council stands, some of these are really unacceptable. And this is the very fight we are having. If the bar, the national bar, can be treated like that at the hands of the judiciary, the judicial officer, who is also a member of the bar, then think about the common person, the person who has no voice, who cannot speak and be heard. At least we can be heard. We have the platforms. And these are the injustices we are trying to deal with, which everyone should be interested in fighting. Fast forward, like Eddie has mentioned, I haven't been around amidst all this. I did return to Kampala last night, which I reached towards morning. But I did spend the whole day today with the Deputy Chief Justice, trying to see how we can handle this issue. And it is so unfortunate, the picture being painted by some of our colleagues who are shockingly members of the bar, whom have personally failed to understand exactly what their interest is, exactly what they want. And the biggest question now for me has become, who exactly do they work for? Who have been laying some wrong propaganda, false propaganda, pointing fingers as if it is the Radical New Bar Council at fault, or as if it is the Radical New Bar that has not done the right thing. Like I told you earlier, we have never sued anyone. It is the bar being sued. We have never frustrated any matter. We've tried to do everything within our powers. We've done everything by the book, just like we've been seeing. And the fortunate thing is we've tried to be accountable to the membership, because we do communicate whatever happens at each and every stage. There's nothing we do in the dark, because we know whatever we're doing is the right thing. It is people who do the wrong things who hide in the dark. They want to do things in secrecy, quietly, in hiding. But we agreed that we need to deal with this. We need to be accountable to the membership. That is what members demanded for. That is what they require. And that is the policy we've agreed to uphold, being accountable to the members, being one of the core values ahead of everything else. If you do remember, taking you back, when we had just come into office, I think about 1 month after swearing in, the very first step we did was send our president to meet the Chief Justice, particularly to lay ground and establish the status of, the bar bench relations, and agree on how we can proceed to advance the mandate which we share, both the bar and the bench. And you do recall the response, the various responses we got from some of the members, some of them being unfortunate, some of them being laughable. But again, it was a focus we had as the Radical New Bar. And if you again recall, the CJ made a clear statement, whereas the president remained tight-lipped at the time, it's the CJ who issued a communication of the meeting with the president of the bar, assuring the public of goodwill and the fact that the judiciary does not discriminate. This is the leader who was voted for, chosen by the members, and they are willing to work with the leadership, the Radical New Bar leadership. The only time I think the president came out to speak was shortly after, through his open letter, because the CJ had promised that we need to have open communication. We need to reach out freely and openly, since we're interested in the same results, since we're advancing the same mandate, though from different fronts. And if you remember that open letter, the president was simply putting across the frustrations of the members of the public regarding the Kabazgurka decision and other matters that were put in that open letter. Fast forward, along the way, we start getting, the detractors infiltrating the leadership. And it was at that stage, if you recall the story of the Munabis and Joffre and group attempting to overthrow the democratically elected officials, that's the president and myself, where we felt, no, this is something that we cannot deal with. Since we have pending business, since we've been planning to hold an EGM, we had to add that as an issue for discussion by the members, by the ones who voted us into office. Had to come back to you because the power lies in the members. We have a mandate of the members, so it is them to decide on some of those big issues. So we had three aspects to deal with. The most important being the election of our representatives to the Judicial Service Commission. I do not want to repeat you had about the RNB Executive Order number 1 and number 2, and the purpose, which was democratization, again pushing for the independence of the judiciary. And again, we still felt we had a good working relationship with the judiciary. We did write to the Chief Justice. I think our EGM was slated for 17th December. So we did issue out the notices and wrote to the CJ requesting that day should be blocked by all the courts, which, by the way, he did, because the CJ immediately responded and granted courts across the country permission to adjourn all the matters on that day to enable us have this important EGM, which, by the way, was also meant to deal with the books of accounts, appointing auditors, which was never done because at the time we're coming into office, some of you were at the AGM. Remember how you yourself said, no, we cannot deal with this. We are not satisfied. We need time to look at them. And after here, the new leadership has to call for an EGM where we shall discuss these books of accounts after studying them very well, because things are being sneaked in and members are not satisfied. So we celebrated. We thanked the CJ. We realized now we're moving on the right path. We're making requests which is responding to very fast. And we thought there was goodwill. But then shortly after came in cases, which I think Jude has explained in detail. And like I said earlier, these were all cases against ULS, cases against the president, mostly by members of the bar who are fully paid up. And, a few of them, what happened with all those cases, how these cases managed to fall in the hands of one particular person, how fast they were tracked and, rulings delivered in record time, how we were denied the right to be heard, how absurd some of these rulings are, to even, I think a year one law student could analyze some of them and know this is all wrong. So it's at this point that we realize this is now a war against the bar. It is an intentional move to frustrate whatever we're trying to do. And like Jude clearly stated, explaining the rulings, of course they had to be appealed against because they were against principle, they were unfair, and we believe they were delivered in bad faith. Like I already talked about the incidences you saw in open court, how we're being treated. I mean, this is the national bar, but the disrespect, the ridicule, and the disregard to, the basic principles of rule of law, fair hearing. When you're dealing with a national bar, these are not individual matters. It was really absurd, and it started sending out a bad picture. And from that point, we did believe now we need to engage GIA number 2 because we must protect our profession, our independence. And it was very clear that some people wanted to maintain the status quo, who for their own reasons best known to themselves felt we shouldn't make a step, and who have this advantage of getting whatever they want as and when, which is another unfortunate injustice we're trying to expose and fight. We're at play here. And again, looking at the situation of how we're struggling with our appeals being heard, and you compare with the lightning speed at which these people's matters against us were being handled and disposed of, where the outcome was definitely always predictable, regardless of how unfortunate it was or it would be. We knew now, as the council, we either on our own or we have the members to back us up, and come and push and fight for what belongs to us. Again, if you remember, after filing appeals, we did file. We advised you to file applications. I think even President filed an application there for stay pending his appeal. Now that is a different topic altogether, because as we talk, it still sits in the civil division. We've tried to push and have it fixed. But I'll come back to that, and I believe probably the President will speak deeper about that. But fast forward with the ULS matters, these applications are noted, and we felt there's important business, like Eddie has been explaining, especially we needed to have these meetings, we needed to have members, we needed to have the Judicial Service Commission operational with our representatives. So we had to withdraw. We had to sit and agree that no, let's withdraw this application from the High Court, since there are no judges, or the judges at the civil division had been taken away. And at the time, it was not practical to have a judge to hear our matter expeditiously. So we felt if we filed in the Court of Appeal, probably would get justice. Would get someone who could hear this matter, a single judge of the Court of Appeal, considering the urgency of these applications and our matters, which is self-explanatory. You don't need to even explain much about how important and urgent these cases are and how much they are holding. So, of course, along the way, what happened on February 7th, opening of the new lawyer, which was very unfortunate, where it was very clear that as members of the bar were not welcome to the compound of justice, the court. And this now sent a lot of shivers, along our spines, because it was unexpected, considering how we had started moving and how we felt we were executing our mandate and moving in the right direction. But now it really appeared like this was now ganging against us. And of course, the rulings that came after justified our feeling. So we went to Court of Appeal, and like Jude and Eddie said, we have, from the position of the governing council, the majority of council, we have been open to any mechanism of dispute resolution that can help us resolve these matters for the better good. And the first mediation at the Court of Appeal was, first mediations were handled by Justice Chiriabwire, who we all respect and know he's the best we have in the game, the best mediator we'd ever have. And much as we felt, I remember personally telling President that, President, listen, much as you might have your own reservations about the intentions of these people, give it a try. Let's get this out of the way. Let's go and listen. Let's go with an open, let's go with open minds. We'll find a solution to this. And I'm glad that he did listen. The President listened, and if you do recall, he did attend these mediation sessions in person. But again, like having a slap in the face as Justice Chiriabwire is trying to find a solution, they're trying to mediate. Again, these people have different ideas altogether. The Vyamazmas are coming with, criminal summons. They are attempting to arrest President. So it was as if he was being lured into the mediation to either have him arrested, embarrassed. So at this point, definitely also felt now we're not on the same page. And shortly after that, the same people wrote to court, withdrawing from the mediation, saying no, because even after this, we said, no, it's okay, let's keep it open. And I remember we had spaces here, I think the Council, Dennis Kusasira, and our candidates were, and they did explain, these people, the Monavian group themselves, wrote withdrawing, saying, no, we're not interested in the mediation anymore. And the arrogance with which this is being done because they are sure they will get what they want is what, for me, used to beat my understanding and made me wonder what the judiciary had become, whether we should keep the trust or not, whether I should believe in what is likely to come out or not. Nonetheless, we said, well, we're still here. Whatever effort will be brought up to have these matters resolved so that the bar is able to operate normally. We're able to have, these elections. And by the way, it is not only elections for the representatives to Judicial Service Commission. We have a heap of requests for representatives to all the statutory bodies, but we do not want to be in contempt of court. We do not want to guide and go against the decision of court, where court directed that for all representations of statutory bodies, we must conduct an election. So here we stuck. And when that mediation failed, we kept. It is wrong that we tried to lobby, and I believe there's nothing like lobbying. In any case, if there's any lobbying now, from this you can tell who is a lobbyist and how people manage to get matters heard before a particular judicial officer, who probably are even the ones who would write the rulings. Let me use that, because how would someone anyway know the outcome even before it is, in the name of prediction? That is not justice. So when that failed, we realized time is running, and our interest is really to deliver. Unlike the previous, Eddie and Jude have tried to explain, we did have another attempt when our applications for stay pending appeal were filed before the single justice of the Court of Appeal. When we reached there before Justice Musisi, we felt, and he also told us, I think these matters are mediatable. You people, I don't see what is hard here. We said that we also don't see it. We are available. We are open to mediation and discussion. And I think at that point the most important thing was, how do we have these elections of the representatives? Because the Judicial Service Commission, I think, had received a request now requiring us to send the 2 representatives. And I remember telling Jude, listen, now that we have these applications filed, we need to take advantage of this. We need to make sure we have this out of the way. And we again went with open minds. So when the judge said, no, this is a matter that can be mediated, I want you to sit and negotiate. So we said it's fine. We sat with the Mnavis, the Joffreys, and the lawyers representing Hashim, I guess. We were guided by the judge. We said, no, we need to put any other personal interest aside. All of us are interested in having this out of the way. It is dangerous to put on hold the constitutional mandate of the whole institution simply because we failed to send our representatives. So we did sit, and we even agreed on the consent. Most of you, like I said, we are always accountable. We share all this in real time. We did agree, as we were guided by the court. Said, no, that is fine. Whatever agreed upon is okay. Come back with the consent tomorrow. We enter it on record. You let the EC conduct the elections. Jude has explained the nitty-gritties of the Fiona Wall matter and all these other matters. I don't want to go deeper. But again, fast forward, we reached there the following morning. And again, these members, the Joffreys, and we're coming up with a different idea, saying, no, we're not entering that consent anymore. We've changed our minds. If you went on court record, you would find that a copy of that consent, which was signed by, by all council members, the majority of council, save for those 2 gentlemen. So the judge said, no, I'm not giving up on you. VP, why don't you call all the council members and come here tomorrow? We had to interrupt the members who are up country. Mumza Samuel traveled from Fort Poto, Mr. Gariman traveled from Lira, Mr. Edin Angu traveled from Bale. They had to travel overnight. And we went back. When we reached court, the judge tells us, now, if you people are saying the challenge or the issues, you need to have a resolution to agree on this. The boardroom is there. You sit. And we sat. Said, whatever I come up with will be a resolution. That's what we shall go by. I think that meeting was even attended by the representative of the Attorney General, who was called in by the Mnavis and the Solicitor General. And we were saying, listen, decisions of council are reached at by the majority. That is the position. Even when you sit, it's the majority. So the judge had even told us, you guys go sit, plan, whatever you come up with, these are the, this is the position. You get here, we shall go by the majority, we shall follow. That will help me make a decision or use it as a resolution. We still do the same and agreed to, much as the EC, like Jude said, was not comfortable, Mr. Master not being comfortable with the fact that we let Fiona Wall be on the ballot to enable us handle, conduct those elections. Since that was the only impediment, we did not want to be in contempt of the court, judgment, however much we're not agreeing with it. So we're willing to bend law. We're willing to really, put aside all the other sentiments, which we did. Unfortunately, we reached court again with a resolution fully signed. That very meeting, President had to attend on Zoom because he was away. And we reached court, and the same members are saying, no, for us, we're not signing that resolution. The representative of the Attorney General says, I need to consult the Attorney General. He's not in the country. And we're saying, listen, we sat there and we agreed. Even the judge promised, some of you are following, said, listen, we agreed. This is a majority, it is 6 members out of these 2. Even if you wanted to add the other 2 either way, it's inconsequential. But at that point, that's when now the judge realizes, says, no, it's okay, I'll give them the time. And just like it has always been, The next thing, we are going back and the judge is telling us now there are complaints from these other litigants, Fiona Wall and team, saying, they don't want the judge in the matter anymore. I again go back and ask the same question, who are the lobbyists here? We did not ask for this. We are being told if you mediate, you'll get a solution. And we sat there, we listened, we did follow, we went by the book, we've always done this. And we reached the point of saying, okay, now we need to let this judge deliver his rulings, as a single justice of the Court of Appeal on the interim applications. And while all this is happening, I see the point of the president saying, now you see why I told you I don't want my application to leave High Court, to come to Court of Appeal. Because I believe this application, it's an interim application, should have been given, chance, should have been heard. Now you see you're even being played in the Court of Appeal. So as we're still there waiting for the ruling, saying now, since we failed to agree, the submissions have been filed and everything, we need to wait for let's wait for the ruling since the mediation has failed. And as we're still there, that's when, like Judas said, now receive, the request to file our submissions, and this was an excitement. We were all excited, and if you remember the day we received the hearing notice for 10, we did share with the membership, and there was jubilation and excitement among its members. Finally, we are going to have our day in court, the Court of Appeal. And mind you, we didn't really, as council and as members, we are not saying that we want a particular decision. All we're asking for is give us a decision, regardless of whatever the outcome might be. All we need is a decision. We need decisions of court on these matters. Most of them are matters of law and principle. That is all we're waiting for. That's what we're hoping for. And upon receiving that, which is shared across, and everyone is excited, and because we know we had at least complied, much as we knew the respondents had not yet complied, that's when now we receive an unfortunate, again, letter from the registrar telling us that instead on the 10th, we are going to appear before her, for scheduling. We're not going to appear before the panel of the judges as earlier communicated, which of course, as the discussions have gone on, we felt it was unfair. We attempted to meet her in person. It didn't happen. And the action I took upon agreeing with council was, the person in charge of Court of Appeal business is the court administrator. Let's go and see the court administrator. We did write, but of course I had to copy in the DCJ himself. Explain to the court administrator our matters was listed. Now there's an attempt to cause list. I think that was on the 3rd. We didn't only write, we went there physically. I spent the whole day with Jude at court and Robert, trying to meet all these people physically and explain our dilemma, because we are not satisfied with the registrar's decision. That wasn't lobbying. That was, trying to demand for what is rightfully ours, our right to be heard. And I remember we found the court administrator was on leave. They told us he was on leave, but he was coming through. He would be around later in the day. We sat at the entrance of the lift where the judges enter from. Said, no, let's wait here. We even said no, also need to address the Chief Justice. If most of you recall, because of what has been happening about, I think around the 20th of June, we, in our wisdom, as council felt, it's getting too much. The image out there is bad, where it appears like we're in fights. We did take it upon ourselves to reach out to the Chief Justice, and I did lead a delegation of council members where we met the Chief Justice and told him, listen, we need to make peace. We do not have any intentions of any bad intentions. Our concerns are legitimate, which we agreed. We had a meeting of about close to 4 hours with, all the council members also traveled from our country in a bid to make sure we mend this bar bench relation. The CJ did not call us. We reached out ourselves. That was on a Friday the 20th. And if you've been seeing, you must have seen the press release by the judiciary for the one of 25th June 2025, where we even came up with resolutions. It was published by the judiciary, not us. We're not the ones who published. And just remember I think the first resolution was that the judiciary and the Uganda Law Society will continue to maintain cordial and professional relations with open communication, coordination, and collaboration in the execution of their separate but complementary mandates. And the Chief Justice again assured us of his goodwill, openness to dialogue, and emphasized the imperative for constructive engagement. We went ahead to reiterate the judiciary's unwavering commitment to the delivery of a responsive, efficient, and people-centered justice. Now, both of us committed. We reaffirmed our commitment to continue the collaboration between the judicial and the legal profession in ensuring justice for all. We felt we were making strides. So for me that day, that was the only reason I did say, no, let's also engage the Chief Justice. We know he's not the head of the Court of Appeal, but in that meeting we had a candid discussion. We agreed that for purposes of maintaining the bar bench relations, we need to have open dialogue. So he even said the same thing, anything, if you have any challenge, my door is open, come, let's discuss and see how we can resolve. So that was the only reason we did go to the Chief Justice. That unfortunately, apart from delivering the letter, we weren't able to see him. And I think when we came back, tried to meet the DCJ, he was rushing for a meeting, couldn't meet him. and I was told we could only meet him on Monday. But now our time was against us because now we're entering a weekend, and this is now a week of, there's an attempt to the cause list. We have a cause list with the cases. We're being told they're being removed, and we feel like it's a matter that has to be attended to urgently. We're not the ones who had put those cases on the cause list. We did not lobby anyone to put those cases on the cause list, but we felt it was the right thing to do. But the wrong thing was, trying to do cause list. Members, we did spend sleepless nights trying to resolve this impasse, and the following day, immediately, that's when we received now a communication from the registrar explaining, giving us reasons why our matters were being cause listed, and we felt that was a wrong reason, like Eddie clearly stated. And now we had to go into matters of law. You must have seen the communication and the letter. I did write. Now we felt it is time to write to the head of the court, the Deputy Chief Justice. Whereas the previous letter had addressed the court administrator, I felt this was now an issue the deputy should, handle. And if you saw the communication, we felt it's procedurally wrong. There's no any legal justification, for, the cause listing or saying that the matter must be, there must be this scheduling conference with the decisions of the very court, security group. The decisions they put and said, no, this is a matter of law. It is wrong, and we're coming to you, imploring you to intervene and bring an end to this. We want to have our day in court on the 10th. All our matters have been put there. Why is it that it is only our matters that are being cause listed and others have not been tampered with? The matters of the same year, 2025. That notwithstanding, we even explained the importance of the ULS matters. Unfortunately, that very day, I lost someone. I had to travel, but I left people trying to follow up. Even after that, later, we attempted to meet the DCJ to discuss further, because I personally believe that we need to keep, dialogue, open dialogue. But it's also good to have a record. Dialogue should follow a record so that, there's a record. There was no wrong intention for that letter. The letter was very clear, saying, this is what the registrar is telling us as a reason. We don't believe in these reasons. They're not legitimate. Please prevail over this court, prevail over your junior officer. Let our matters be heard. We even tried to meet the judges on the panel because we felt we were being unfairly treated. We felt we were under attack. And for us, it was an assumption that probably even the DCJ doesn't know what's happening. That's why we are being tossed around. So we need to bring it to his attention. All of you saw the unfortunate letter which someone called Saba Saba, which was a response. And for me, I think I was away for burial when I saw that letter. Honestly, I first, sat back and realized we were on different pages. We were reading from different scripts. Because I think from the part of the DCJ, it was now an open fight. It was bare knuckles. It was now personal. The emotions, the anger, and everything. And good enough, on Monday, I think our chief executive officer had again appeared there with Jordan Engage. Jim told him, no, the vice president is not here. I honestly, while writing that letter, did not mean any harm. We did not, the intention wasn't to, to annoy or to offend the person of the DCJ or anyone. We are simply putting the record straight, saying, no, this is wrong. We are demanding for what is rightfully ours. We need to have these matters. They are important. And the reasons that are being given by the registrar are not valid. We have the legal arguments here. Decisions from this court. These are the rules of court. Let's follow this. But then again, that appeared. It called for, a fight. And again, from our position, we are saying, okay, it seems people misunderstand, radicalism and principle and, the approach. So again, I did return last night. Today, the whole day, like I've told you, I was there with the DCJ, still pleading, saying, can we have our matters cause listed? Can we have our matters stay on the cause list? We need to get out of court. Tomorrow is the court day. I still believe we can have this, trying to still show the importance. Now, from my position as the vice president and trying to execute the mandate of representing the president in his absence with the council, we do believe we've never closed dialogue. We've never said we are not open to a discussion. The only challenge is that every time we try this, we are left with an egg in the face. And we keep getting questions. Now you're doing this. At the end of the day, you're being, you're the loser at the end of it all. But we keep saying, for the good of for a greater goal, I feel we still need to have this engagement. And we did. Of course, we had a lengthy discussion for over 2 hours with our council members. The treasurer, Mr. Gar, also had to travel. We even had senior counsel already because he represents the president in his matter, trying to still show the DCJ the importance of these matters, the impact of not having, how it affects the general public, these other statutory bodies, constitutional bodies. We cannot wait for these 10 years. Our matters are actually important, and they should be treated as so. We're not saying others should not be heard, but we feel matters concerning the national bar, considering the goodwill that was promised, they affect the very fabric of access to justice in the country, the operation of so many entities, and they need to be dealt with decisively. And again, we retaliated. I said, listen, we do not actually mind the decision that will come out, but at least let us be heard. We can deal with the decision. And again, I wouldn't really want to go much into the detail, but again, the same points of I think these matters can be mediated. I mean, we've had how many mediations? And again said, listen, on our part, we've never closed, we've always been open. Even if judgment is tomorrow, you can still reach a consent today. Even that very day, you tell court, listen, you're going to read your judgment, but you keep it. This is our consent. We've come up with our own. But the most important thing, we need to have our day in court. I need to take you back briefly to the president's matter itself. When his application was filed in the High Court, in the Civil Division, and we did, at that time, the Civil Division, all the judges were leaving, and there was no judge. So when we get the head of the division, I did personally write to the head of the division, saying we need to have, I don't know, Ed, if you have that letter, you might have to read it for the members later or share. Do you have a copy? Yes, I did write to, the moment you got know that the head had reported, because after being posted there, I think she was on leave, spent another period of a month, then she comes back, she's in another session. I did write, say, before the Civil Division begins work, we prefer having, a discussion, a meeting to discuss the bar bench relations of this court, the Civil Division. It has had problems over the years, but before we even get started, we need to sit and discuss and share our challenges. We bring in recommendations. But at the top of it, please prioritize. We have two matters here. The president's application for stay, he has a pending appeal, and we had filed a habeas corpus application in Kiza Aaron's matter, which was never heard. In fact, those were matters of principle. I did move to that Civil Division, I don't know how many times. Personally, sacrificing, Eddie talked about practice dying, but for a better good, it's a sacrifice. I did work there several times. The letter is placed on her desk, it is not addressed. It is not responded to. They keep telling me, you wait, we'll give you an appointment, we'll give you an appointment. All I was asking for was, let us meet you as members of the bar. We discuss, we agree on, a bar bench meeting, a big one, where the members who practice in this court can share their views so that we have a clean slate. You begin on a good footing, but you also need these matters handled. The president's matter concerns his liberty. These are matters concerning personal liberty. The most important of all. Everyone knows once this matter has been brought before you, you put every other business aside. Habeas corpus application is an interim stay. And for me, I found it interesting that we're even having the main appeals fixed for hearing when the application has not been addressed. If this judge had given us attention, the only thing that was done was, okay, the president's application is fixed for hearing, I think on, I don't remember the date, in June, and we are going excited, saying, okay, now at least if we get a stay, there's some kind of relief, because since the appeal is not moving. Unfortunately, the same judge decides to adjourn this application, a simple application, for over 2 months, somewhere in August. And the question remains, is there really goodwill? Our request for a meeting was never, was ignored completely. Now, who will say that we've not done whatever it takes? We've not taken all the necessary steps to ensure that we do work together. The bar and the bench, we keep telling them, you cannot work in isolation, we must work together. And we've done our part. Now, I'm trying to set the record straight so that the members listening get to know the proper story, get to know the steps we are taking to ensure that we execute this mandate, which is completely different from what some, wrong elements, I must say, some selfish individuals who are members of the bar, the notion they are trying to sell, the story they are trying to sell. One wonders, who is the beneficiary to all this if everything is frustrated? We've tried to deliver, do business as usual. And a lot of things, which I cannot actually say here. But again, you have people who are coming up trying to sell this stupid nonsense that we are the ones frustrating this, we are the ones who do not want these things to be done. It will take me back to the same question, who is an enemy to the bar? And again, another question I would ask, what would you do if you hear a call saying, okay, now tomorrow we are getting up, we're going on the tarmac, we need to have, we need to be heard. Who is going to blame anyone who will appear? Who's going to blame anyone who's going to use other means for demanding for what is rightfully ours? So colleagues, I do feel as your leadership, as your leaders, we've done everything by the book. Amidst the hardest of the conditions to operate, imagine having a president of the bar who is out of jurisdiction, who cannot be in the country because some elements failed, dissatisfied with, the outcome of an election. I mean, by the time someone gets 70%, over 70% of the votes in the most highly attended election, or the election that has been most participated in by the membership, that should send you a message. This is the member's mandate. How do you come out as a minority, as an individual, to try and fight that mandate? And I want to believe everything that was promised is what has been done. Even amidst the frustrations, the very unfortunate, hard conditions, we still do try to deliver. we still do try to deliver this mandate which was promised, because once you've crossed that line, you're now in leadership, you must focus on doing what the members have sent you to do. And I don't see anything we've done outside what the members sent us to do. This is what we continue to do. So for me, the end game really is, how can we point out these characters that feel and believe that they are more powerful than the 6,000 members? And what solution can we have for them? Because again, like I've clearly outlined, our role in delivering the mandate has been played. We've used all the possible avenues. And one thing I can assure members is that we shall not relent. As the leadership, we shall continue doing the right thing, what the members sent us to do. I personally do not care how long it is going to take us to get out of this, as long as we are saying the right thing, as long as we are not committing any wrong, because this is what the members sent us to do, and that's what we are delivering on. We are democratically elected into office to execute a democratic mandate of the majority. And that is what we stick to. That is what we are trying to do. So some of us have already sacrificed a lot. We've already put in a lot and lost a lot. But the question is, how many of you are willing to come out and do the same? Or are we going to keep folding our hands, going on groups and making all sorts of complaints, making all sorts of suggestions when you cannot come out and stand? You saw the massacre chapter coming out, strongly saying, no, listen, enough is enough. We are laying our tools down because of, we're not being considered. And they stood their ground. All they required was the support of the bar, which we did. We did the platform, and again came on board. If you do recall, the reason that strike was actually temporarily put on hold, I believe the judiciary did not have an immediate answer to that. There's no way they could have handled that situation. But what was being affected, it's not just the lawyers' businesses, it's the general public, the members who seek justice. All that was being done was blame the members, blame the lawyers, and pointing fingers. We believe the blame was going to the wrong party, but we again provided leadership and came in to salvage the situation. Now, if we are the wrong people as the leadership, if we are interested or we are thriving on chaos and confusion like some members are trying to say, would we have taken the stand, said, no, listen, let's have a discussion here? It is the leadership that did resolve that impasse and try to have a balance through dialogue. So if it is dialogue, we've done dialogue. If it is engagement, we've done engagement. If it is reaching out, we've reached out more than anyone else. So the question remains, and this is what I leave for the members, what is left for you, what is left for us to do that you feel we've not done? Thank you very much for listening to me. I hand over back to you, our most perpendicular Interim Secretary, Eddie Nangulo.
Wow. VP, thank you for those moving words. What is left for you that you feel we haven't done? Wow. We thank you so much for that elaborate detail, Mr. Vice President. I had a number of things to ask, but I don't want to water down your closing remarks. I want those ones to first linger in the minds of members. Maybe we shall ask questions later. What is left to do that we haven't done as a radical new bar? Very interesting, very important. I go on to welcome those who have just joined. I see our key Eastern Stalwart. I see Napa Joffrey on call. I see Wahib on call. I see Omongot on call. Earlier I'd seen Dr. Ruheza and many others who keep on joining. You're most welcome to this dialogue here. Not to have the VP's moving words watered down, I would want to go on and invite the next discussant, Mr. Garo. Mr. Garo, he's our council member from the Northern Region. Mr. Garo has served us faithfully. He has been one of the most radical stalwarts, the radical new bar. He has been at the forefront of our programs at the prisons. He has led from the front. Today he was meeting with the DCJ together with the VP. I want to offer him a platform to share his thoughts on the standoff that the VP has been trying to break down. Mr. Garo,
Sorry. Before Garo comes in, I did allude to the communication. There are two letters I sent to you. The one we wrote to the Civil Division specifically concerning President matters. I asked if you had the document because you hadn't read it amongst the ones you read. I did send it to you. I wanted you to go through for the members before you call Garo online. The two letters, one to the CJ and one to the head Civil Division.
Okay, Mr. Garo, please, just hold your horses. Members, there are two letters that the VP referred to in his speech. Again, I was saying that I didn't want to water down his moving words, but don't forget his parting question. What more do you want us to do that we haven't done? Here's the letter that is written to the Chief Justice. It is dated 16th January 2025. The reference is a request for a consultative meeting. Dear Chief Justice, greetings from the council. management and staff of the ULS. I'm writing to request for, I beg your pardon, I'm writing to request an audience with your office before the 26th Annual Judges Conference to discuss important matters of bar bench relations with a view to salvaging the working relationship between the legal profession and the judiciary of Uganda. For this historic consultation with the Radical New Bar, I will lead a high-level ULS delegation who will meet you to present the hot button issues for the new year. To conclude any matters of protocol, please don't hesitate to contact my Vice President, and the numbers are listed there. This is a letter issued by the President himself to the Chief Justice. The second letter is addressed to the Head of the Civil Division, Honorable Justice Joyce Kavuma. It is dated 29th of April 2025. The reference is congratulations and request for meeting on key matters. Greetings from the Council and the management of the ULS. Congratulations on your appointment as head of the Civil Division of the High Court. We are confident that your leadership will bring renewed vigor to the division. We respectfully request for a meeting with you and the Civil Division judges to discuss, one, planning for the upcoming Bar Bench Forum and annual law conference, and the key matters affecting bar bench relations, specifically miscellaneous clause number 33 of 2025 into brackets ULS versus AG. B is miscellaneous clause, number 2 is MA number 137 of 2025 Isaac Semakade versus Mugisha Hashim. Could you kindly suggest a suitable date and time? We look forward to collaborating with you, the Minister of Justice. Yours sincerely, Mr. Simwe Anthony, Vice President, ULS. Okay, those two letters there were referred to by the Vice President in trying to indicate different manner of trying to broker relations, address the standoff, promote mutual relations. There are keywords that the VP used, which I will ask him about later. VP alluded to seeming goodwill, and VP, even as you have a glass of whatever you would be sipping this evening, you're calling the goodwill seeming, as though it is pretentious and not actual. First the meeting with the president, then first the CJ meeting with the president, then the CJ meeting with the council, and after all these seeming well-intended meetings, you say that they throw at us cold eggs, but me, I would think they slap us in the face. First as the new lawyer, now the DCJ slaps us with a rant of as long as I have breath, I will not relent. The standoff debate continues. I will invite the VP at a later time. But we continue. I want to invite Mr. Gar. Mr. Gar, I already laid down your particulars. I will not say that, my brother, but the floor is yours.
All right. Thank you very much, the moderator and our interim secretary and Eastern representative. My colleagues, the council members, and I salute to our president and all the colleagues and members who are here. Ladies and gentlemen, I've already been introduced, so I would like to go on just to give my thoughts. First of all, I want to thank you so much, Eddie, for laying the background quite well, and also our counsel, Jude, and also I want to, in a special way, thank you, our Vice President, for giving a very good keynote address, and for being there for the Radical New Bar. We want to appreciate you so much for the good work you're doing together with all my colleagues at the council. Members, already I want to agree and confirm that what our Vice President and Council Eddie have already submitted on clearly reflects what we have been doing for all this while, right from the time we were given this mandate to lead Uganda Law Society. Right from the onset, or right from the beginning, as guided by our president, ours is Radical New Bar. And radicalism is about focusing on what matters, basically on the rule of law, and ensuring that all the spaces that belongs to the bar are all protected. And so a lot has gone, as already explained. And currently, over this weekend or this week, as we, the main, what has been dominating news or discussions is basically the standoff between Uganda Law Society and the judiciary, which, in my view, there is actually no need for this impasse. But I want to believe it's a clearly, let me call it a group of people who have probably misconceived or are deliberately fighting the bar meaninglessly. I mean, what we are focusing on is very clear, our job is to represent and provide leadership to the bar and ensure that our rights are protected, the rule of law is observed. We as lawyers or members of law society are practicing or are doing our work, our profession, with grace, with honor, professionally, and things are done in the right way. But of course, as already has been alluded to, detractors and people who have selfish interest, selfish, I mean, probably have what they gain from what they're doing. And apparently, as already alluded to by our secretary and interim secretary and the VP, especially on our cases, it was very sad, very, very sad to see our cases being de-cause-listed. And indeed, the reasons that have been given, as already alluded to, has no legal basis, is not grounded on the law. Clearly, I would say that indeed these are not the ordinary days. These are it's not business as usual. But ask the elected leaders. Again, our job is to provide leadership in situations like this. What has happened clearly, even a person who is not a lawyer sees it clearly that there's a problem. There was no need really for us to be where we are now. And so I want to thank you, our members of Uganda Law Society, for all the support. A number of you have come up to rebuke and to condemn what is going on. And rightly so, all of us indeed have a right, have a stake. We as stakeholders, we can't sit back and continue to watch and continue to see what is going on. It is very important that as a profession, as members of the bar, as leaders, we need to stand firm against all odds, against this situation. If we can be treated like this, a treatment which we don't deserve, because we actually, from one mother, the members of the bar and the judiciary, we are one and the same. And so instead of this impasse, we should be working towards a cordial relationship. And if we can be treated the way we are being treated, what about the ordinary member from the community, the people whom we represent? So what is going on speaks volume about the judiciary, speaks volume about the leadership, speaks volumes about what is going on. And clearly this should motivate us to even fight more. This should motivate us not to relent. This should sincerely motivate us to come out and stand firm and ensure that our spaces are protected, our rights are protected, we are stakeholders, our society is not hampered to the extent that we cannot operate the way we should do. And so, without having, I don't want to keep repeating what my colleagues have already mentioned or stated. For me, my call is that now is the time for us to wake up. Now is the time for us to stand firm. Now is the time for us not to relent. And to ensure that we achieve this, we need to objectively speak one voice. We need to come together, regardless of where we come from, regardless of our background. We need to stand firm. We are family. We are members of the bar. We need to demonstrate the highest level of unity, highest level of cooperation. We need to show that we understand and we know what we are doing. If our colleagues and members of the East African Bar are coming up strongly and supporting us and standing with us, then what about us? We then need to, justify why they should, do what they're doing, why they should stand with us, why they should, ensure that we succeed. And so I make this as a clear call to you, my colleagues from the Northern Bar, where I represent, and of course the colleagues across the country, that we are on the right track. We just need to focus more and pursue our rights and ensure that we are listened to. And that is why we are lawyers. There must be a difference between us and others. People are watching. People are saying, okay, what are lawyers able to do? Can they come together as a family? Can they stand firm? They speak for us. Now, can they speak for themselves? Can they defend their rights? So, at all costs, we need to stand firm and ensure that we attain justice. I've had a number of people talking and saying, it seems as the members of council, we seem to be the one who are not interested in having these matters resolved. We are not interested in mediation. But like already has been mentioned, personally, I've come severally from the north to come and attend to these matters, to participate in these mediations. But Participating in a mediation, there's nothing wrong with it. But what is very key, what is very important, all parties must be genuine for you to achieve the intended results. If one party is genuine, one party has come in good faith, and the other has not come in good faith. Because I've seen several times when we're having this, trying to have this matter mediated, most times we are our colleagues from the other side getting instruction from somewhere else. They get calls, and all of a sudden they are talking of something else. Clearly, it shows that there are people who are behind this. And so, as members of the bar, let's not relent. Let's stand firm. I believe at the end of it all, we shall achieve justice, and we shall come out victorious. For now, I would wish to stop here. Thank you very much, members, for listening.
Mr. Garu, thank you so much. I'm also against watering down whatever you have said. The rallying call is very persuasive, very charismatic. Anybody who hasn't moved to join you on the tarmac, surely must now be on the road. But before even you take a break, Garu, I want to just ask you a follow-up question.
Yes.
You're advocating for unity. Is unity of the bar a solution to address the standoff, in your opinion? Are you saying this in a way that if the bar unites, maybe we won't have lawyers suing each other, or maybe we won't have these frivolous matters being filed? How does unity play into the standoff?
Yes, my view is that we are family, we are members of the bar. And so if there are small bickering, things that doesn't take us far, especially those who are, who are causing all this, it doesn't help them, because where will it take them at the end of the day? Can we stand with the voice of the people? This mandate was given by over 70% of the electorate. I want to believe that just a handful of people who are causing all this. And so, if the judiciary sees that indeed we are firm, we are speaking one voice, the few people who are we call them detractors, certainly they will, they will follow. And so, it is important that we stand as a family. We stand we stand together. And so, it is a big sacrifice. I know there are a number of people who are standing with the radical new bar, but standing with the radical new bar is not only standing, having it in your heart. When we make a call like we are doing now, I'm calling upon members that let's demonstrate that unity by coming out to prove to the world that indeed enough is enough. We need to move on. That is what I meant.
Mr. Garu, will you be on the tarmac tomorrow?
Very much so, Council Eddie. Very much so.
Thank you so much, Mr. Garu. Thank you for your thoughts. Thank you for leading the North and being at the front line. I want to pass on the baton to our beloved treasurer to expound also on the impending standoff. What is the way forward? What do we do? His thoughts similar to the thoughts of Mr. Garu and the Vice President. But maybe even to begin from a point, do the courts indeed have goodwill towards the bar? Is there any goodwill? We have gone into these discussions here, but Mr. Seko, today you were in a meeting with the Deputy Chief Justice, and before that meeting, we had a council meeting. Do the courts have goodwill towards the members of the bar? Do they wish us well, or do they view the bar as a threat that they must silence and stamp out? Over to you, our treasurer.
Council Eddie, the treasurer, most of the treasurer is not on the call, he's not in the speaker section. I had sent him a mic request earlier, and I'm thinking.
How about our council member Western, Mr. Sam Mohomuza? He had assured me that he is on call. Do you have him on? As you get for me, either Sam or the treasurer, I would again go on to extend thanks to the members. We're discussing the standoff, the seeming goodwill. Is it actual? Is there good faith, or it is pretended justice? I see Mr. Council Muchivi on call. He has been, I think, the most radical critique of the bench. We shall have thoughts from him as we carry on. Mr. Muchivi, as you listen in, the CJ said he won't give us audience. He won't let us speak, and we are struggling to have our voices heard. Are they implementing his directive? When the DCJ says we have to wait for 10 years, is that a form of implementing, or it is a mere coincidence happening at this point in time? Adam, do you have anybody for me on call?
Not really, Professor Mshiba. I've sent him a mic request, yes, and maybe to allowing these mic requests, which I'm seeing. If at all, maybe they have a question. Yeah, I've approved the president.
Okay.
I can see Gachiza, I can see Garothigo, Stephen Rennie. I wanted at this point of time to wait approving people so that
we get a Councilor Western or the treasurer. Council, we have on call Council Inen. Council Inen had the most bearing remarks. He quotes the words of the DCJ. Maybe we can pose to him a question.
Yes, Council, Eddie,
yes, yes.
the president is on the call, and it seems